Good afternoon, ladies and gentlemen. We have two applications here, as I said. There is one seeking to strike out NASA out of petition number 4. And then there is one seeking to join Jubilee to petition number 3. We will start with the one seeking to strike NASA out of petition number 4.
Just a clarification, my lord. In petition number 3, there is also a jurisdictional challenge as to whether this court has jurisdiction to entertain petition number 3.
Yes, we will deal with that.
Most obliged.
Yes. Mr. Ngatia.
Yes, my lord.
We said we have very, very limited time.
Yes.
An application like yours,
Yes.
you should be able to argue it in 5 to 10 minutes.
Very well.
Yeah, please.
I'll keep an eye on the clock.
Okay.
My lords, the petition that was filed maybe in 2 installments on 6th and 7th seeks 2 orders. The first order is a declaration that the third respondent was not validly declared as the president-elect. And the second the second relief being that there should be a fresh presidential election. To all intents and purposes, this is a petition to challenge the election that was held on 26th October this year. So the first question that really comes to mind is what is the role of the 4th respondent in this petition? What is the role of the 4th respondent in this petition? Let me first and foremost, my lord, say the application which is now before you is supported by an affidavit. The depositions in that affidavit have not been challenged. There is no affidavit to challenge any of the depositions in that affidavit. What we have, my lord, are grounds of opposition, which I'll deal with as I argue the application. My lord, I have explained that there is a petition. It was filed. In paragraph 88 of that petition, you see an admission that NASA boycotted the elections. NASA boycotted the elections. And what happened is after the petition was served on the 4th respondent, a response has been filed by the 4th respondent. In paragraph 23, the 4th respondent admits that their candidate abandoned the elections. My lords, there must be a legal meaning to a boycott of the elections. I have a direct authority on it. My lords, at paragraph 30 of the answer to the petition is a new petition going all the way from paragraph 30 all the way to the end of the answer is in essence a new petition. A new petition that now speaks to matters that the petitioner could not. For example, in paragraph 51, my lords will notice that new persons are now implicated in the conduct of the elections. Paragraph 52, the same thing. things that the petitioners could not say are now said by this political party. My lords, interesting enough, there is a relief sought in the answer. Interesting enough, the relief is that the president-elect be declared as not having been validly elected. So this is not really a response as we understand it. This is another petition. Why do I say this, my lords? It is quite elementary that if once a respondent has been served with a petition, a respondent who does not wish to oppose it files a notice within 3 days. Once he has filed that notice, he keeps quiet and silent forever. It is the respondents who wish to oppose who are required to file an answer. I am doing no more than repeating Rules 9 of your rules of 2017. The rules do not contemplate a respondent who now says he is answering a petition, but what he does in essence is to file a new petition. My lords, I have absolutely no doubt, my lords, that reading this answer from paragraph 30 all the way to the relief, you will come to the only conclusion: this is another petition. It is a more, so to speak, politically charged petition than the petition I have answered to. This is a petition that now starts to implicate so many Kenyans who cannot come to this court and say that they were not involved in any of the malpractices that are alleged. My lords, we have a very unique situation, and unique situation calls for unique solutions. What is the solution that cries out in a situation like this? My lords, straight away, you see the difficulty that I am in. Under the rules, I cannot answer to this new petition. There is no way that we can answer to this new petition. And what my learned friends, if you do not allow this application, what they will be saying with constant refrain is their allegations have not been answered. They have not been answered because they came at the close of the pleadings. The close of the pleadings is, again, set out in your rules. My lords, I go to the legal difficulty with the sustaining or allowing this irregular practice to go on. I am looking, my lords, at Article 50. We are entitled to a fair hearing in this court. That fair hearing, my lords, cannot be limited because my lords are aware that the right to a fair hearing cannot be limited pursuant to Article 25. Why can't there be a fair hearing? There can't be a fair hearing, number one, my lords, because as I indicated, the time for filing answers is long gone. So this pleading will remain on record as undefended. The allegations, my lord, will remain unanswered. That will go against the most cardinal rule of a trial, the right to be able to rebut the matters which have been alleged. My lords, turning to the next issue of this irregular practice of a party strategically placing himself as a petitioner and having another person as a fourth respondent, we are sandwiched between two petitioners in essence, because in my submission, the fourth respondent is in truth a petitioner at the same level as the petitioners before you. It will not be possible, my lords, to be able to answer two petitions, one which we have answered to, and another one which cannot be answered to. My Lords, it is very, very uncommon to come across the situation which is before you. I did read as much as I could to see whether a party who has boycotted elections could come to the court, as this party has done, and I have found an authority from India. There is a supplementary list of authorities. I found fairly late last night an authority from the Supreme Court of India. This is in the supplementary list of authorities we found this morning. And, my Lords, it is at paragraph 9 of that Supreme Court decision that they define the effect of withdrawal from an electoral contest. It's a very interesting sentence, very brief. The fact is that the withdrawn candidate is no candidate at all. He has simply gone out of the picture. Withdrawn candidate has simply gone out of the picture. My Lord, it is common ground, and this is a common ground, that the candidates under this assembly or coalition of political parties called NASA withdrew their candidates from the fresh presidential elections. That is common ground. Their involvement, therefore, in this context cannot be understood in any reason other than that of coming to, so to speak, confuse issues, prolong the trial, have another advantage of throwing challenges and political rhetoric in this contest. That, my Lord, is not the point that we should be dealing with. We should be dealing with a petition which can be regularly answered and regularly prosecuted. In the situation that we are in, that cannot be had because, my Lords, as I have indicated, it will not be possible for us to have a fair hearing in whatever color of that fair hearing expectation. My Lords, I conclude by requesting the following. Please strike out the fourth respondent from this contest. The fourth respondent, if they so wished, could have filed a petition. As a matter of fact, the latitude in Article 140 is very wide. It talks of any person can file a petition. A time period is set out for when to file that petition. The constitutional timeline is 7 days. What you now have, my Lords, is a disguised petition filed outside the constitutional timeline of 7 days. I come from the school of thought, my Lords, that these timelines are not made in jest. They are made to be complied with. Because the minute we do not comply with these constitutional imperatives, then we send a signal that these timelines are made for jest. This is a petition filed hopelessly out of the 7-day period. My Lords, it is not a petition that should be entertained at all. The second request I make of you, my Lords, is that the pleadings filed by this coalition be expunged from the court record. They are unnecessary. They will confuse us as we move along. There are lots of video recordings, a lot of internal memos. As a matter of fact, they have more internal memos from IEBC than the memos I applied to be struck off. They appear to have been more in bed with IEBC than the petitioner. They have more memos in their petition than the ones I applied to be struck off. I am not applying to strike off those petitions, memos. I'm applying to strike out everything they have filed. My lords, nothing less in our very respectful submission will be sufficient, because to allow this to go on, my lords, would be to have a situation where there cannot be a fair hearing. And before I sit down, my lords, when my worthy colleagues take to the floor, the question they ought to answer is as follows. Now that they have filed these pleadings at the close of the time the pleadings have been closed, how do they expect us to answer them? It's as simple as that. Because if they have no answer to that, my lord, then the only way out is that the door be shut and they be told there is no process, no system of allowing a complementary petition. This is really a complementary petition to complement the petition that was filed maybe within time or just slightly out of time. I'll therefore ask you, my lords, to strike out everything filed by this coalition so that we can have a regular trial before you. My lords, that will be all. There are authorities that the authority I have referred to is before you. The relevant part is at paragraph 9. That will be all.
Thank you. Thank you, Mr. Ngatia.
Most of them.
Yes, Mr. Mwangi.
Yes, my lord, I'm going to start my response on a very unfortunate note. First, by reading to you.
My colleague has pointed out to me, it's Rule 11, not Rule 9.
Okay.
Yes, Rule 11.
Okay.
Sorry about that, but for the record, it's Rule 11.
Yes, Mr. Mwangi.
Yes, my lord, I said I'm going to start on an unfortunate note, in that I have to call out the senior counsel for a hypothetical positioning. And I am reading the third respondent submissions, paragraph 67 and 68. Third respondent says that the third respondent submits that the failure to tender a withdrawal as contemplated under Regulation 52 of the Election General Regulations, the fourth respondent, presidential candidate, did not legally withdraw from the 26th October 2017 presidential elections. And in paragraph 68, third respondent counsel proceeds to say that the third respondent is not aware of any Form 24A that was delivered to the second respondent by Raila Odinga at any time. No evidence has been produced by the petitioner of Raila Odinga's withdrawal from the fresh elections, either within the time allowed by law or at all. But he has just now come before you and based an entire application on the basis that Raila Odinga boycotted the elections. So they're blowing hot and cold on one issue, when now it serves to support the application for striking out. Their position is that there was a boycott. When it serves to give credibility to the election of 26th, then the position becomes that Raila Odinga was a candidate. But notwithstanding, my lord, I think the question that should be before this court is not, as asked by my learned senior, what the role of the fourth respondent is, but whether the fourth respondent is a necessary party to these proceedings. And again, I will start again on the third respondent's own submission, because throughout the submissions of the third respondent, they have made various allegations against the fourth respondent, I will just highlight the paragraphs and the pages in which they are. Paragraph 9, paragraph 12 of that is on page 2 of the submissions. Paragraph 39, and what I've read, paragraph 67, paragraph 68, paragraph 69, paragraph 111, paragraph 112, and paragraph 118. Sorry, and lastly, paragraph 139. All of them raising issue with the conduct of the fourth respondent in the matters relating to this petition. I will also, in the petition itself, wish to refer you to various paragraphs in which matters relating to the fourth respondent have been raised. There is paragraph 18, subparagraph G, H, I, and O of the petition. Paragraph 79, paragraph 81, paragraph 84, paragraph 88, and paragraph 93R. The question would be, in those circumstances, what was the appropriate response of the fourth respondent once filed in a petition in which its conduct is the basis of some of the prayers that are being sought by this court. And our response was to respond to the petition by placing before the court matters which we think explain the situation in which we found ourselves in. And being a legal proceeding, you can only respond by placing before the court the law and the evidence. Though it is suggested that all we needed to do is make an acclaim. We don't agree with everything entirely, that with many things on which the petition itself is based, and on many allegations that they have made, which we shall at the hearing point out. But my lord, it cannot be suggested that in the light of allegations that are made against the fourth respondent, both in the petition and in the response of the third respondent, that we were not supposed to mention any matter which we thought would be central before this court in reaching a decision. My lord, to go into an argument now on what would turn out by our participation would literally mean that we have to present our case to you now and to prove to you that our appearance before you is proper and that our submissions before you are proper. I believe the right place to do that is during the hearing of the petition. As we have been able to show, we do have, and both the petitioner and the third respondent themselves have laid the basis for us to be before you and for us to come and place matters before you. Another issue that is also hypocritical of the third respondent is that they say that by the time we filed the response, we locked them out from replying because the time for making responses was over. But that applies to what they say in the submissions, because I don't know at which point they also anticipated that the fourth respondent is going to answer to those things they have said in the submissions. So the same accusation they are making on the fourth respondent is the one they themselves have already committed. Because if they thought that it was right that somebody should have a chance to say something after the last documents have been filed, they would have avoided making the allegations they make against the fourth respondent. They are not even offering to withdraw those allegations that they have made and the accusations that they have made. For that reason, my Lord, this application should be dismissed. It would be a grave injustice to the fourth respondent for a petition to go into hearing, its conduct, and the conduct of members and officials to be discussed, and at no time during that entire hearing are they given a chance to place before the court what their position in that matter is. That is all, my Lord.
Thank you, Mr. Mwangi.
Mr. Mwangi, address rule 11.2.
My Lord, in respect of the documents.
What does it mean when the rules say that a respondent ought to either oppose the petition or what does it say in 11.2?
Yes, my Lord, our position is peculiar. When we begin from the point that we are brought before this court and we have been sued and made respondents in these proceedings. If our question and our answer to this petition is not a straight yes or no, and in our case gets complicated by the fact that many allegations are made against us, we would say yes. If we were to merely support the petition, we would say yes, we do support the petition. But to do so without explaining our position on many of the matters that have been said would literally mean that we are accepting the petition and agreeing to everything that has been said, including the various accusations that have been made against the coalition and its officers and members.
Okay, thank you. Mr. Ngatia.
Yes, my lords. A very quick answer, my lords. The word boycott is in paragraph 23 of the fourth respondent's answer. They say they boycotted the elections. They don't say they withdrew. They say they boycotted. And of course, boycott is a political position. Withdrawal is more akin to a regular withdrawal in accordance with the rules. My lords, my learned friend Mr. Mwangi was hard pressed to say, or could not say, what is obvious. There is no relief sought in the petition against the fourth respondent. Absolutely no relief. As a matter of fact, there are no allegations of an adverse nature against the fourth respondent. In our answer, there is no relief sought against the fourth respondent. Because once again, there can't be any relief because the central focus of the petition is the president-elect, whether the declaration was valid or not. Other political maneuvers, my lords, have no direct bearing to how this petition will unfold. My lords, when you read these petitions, there are numerous persons who are mentioned. It doesn't mean because they are mentioned they become a proper party. The proper party in my submission has got to be the national returning officer who did the declaration, the electoral body that conducted the election, and the president-elect. Those are the three proper parties in a presidential petition contest. My lords, last I met my good friend, he was a crusader for the right to be heard. I knew of him as a crusader of the right to be heard, a prolific writer on the right to be heard. He cannot say how then I will have that opportunity I'll have that opportunity to answer to the relief he has sought. My lords, in conclusion, I think the answer, amongst other places, turns on interpretation of, say, Rule 11, Sub-Rule 2. It contemplates two situations for a respondent. A respondent who does not wish to say anything, he files a notice and holds his silence. Alternatively, a respondent who wishes to oppose. it does not contemplate a respondent who takes that opportunity to file a new petition. For those reasons, my lords, I would ask you once again, please allow this application to enable a fair trial to take place.
Thank you. Thank you, Mr. Ngati. Now, Mr. Mbugwa, who is appearing for the seat Jubilee Party.
I am not.
Yes. Oh, Mr. Rigero.
Thank you, my lords and ladies.
Yes.
Njoroge Regero, appearing for the Jubilee Party, which is the applicant in the application before you for joinder as an interested party, the proposed interested party, in presidential petition number 3, 2017, filed by the Institute for Democratic Governance against the named respondents. Our application is dated and filed on the 13th of November, and it is supported by an affidavit sworn by one Mary Karen Keegan Sorobit, who is the Deputy Executive Director and Director Legal and Compliance of the intended interested party. We have in that supporting affidavit, my lords, my ladies, set out the grounds upon which our joinder in this petition is highly merited. And just to run you through those grounds very quickly, I just want to start with what the law says. What must we demonstrate to this court so that you may admit us as an interested party? And we have recent decisions by this very court in petition number 1 of 2017, Raila Odinga versus IEBC and others. And you had occasion, my lords, to consider applications brought by presidential candidates. One of them was Michael Wainaina Mwaura, and the other one was Ekuru Aukot, and to consider the tests that must be met before you could admit a party as an interested party. Citing your decision in the Michael Wainaina Mwaura case, paragraph 15, you set out 3 tests. Firstly, that the personal interest or stake that a party has in the matter must be set out in the application. It must be an identifiable stake. Secondly, that there has the prejudice to be suffered by the intended interested party in case of non-joinder must also be demonstrated. Finally, you see that an applicant such as that must file the submissions that it intends to rely on upon joinder. We have met all 3 tests, my lord. And if you look at the supporting affidavit, I will demonstrate very quickly how we have met those tests. In paragraph 6 to 15, we have shown you what our identifiable stake is. And essentially, it is this. The petition number 3, which we have perused closely, deals mainly with extensive acts of violence and intimidation, which created lots of chaos and mayhem and bedlam across the country, and amounted, in effect, to very serious electoral offenses. And as far as our membership is concerned, we have given you the reasons why we think we ought to join here. And in those paragraphs, we have told you that from paragraph 6, we represent the interests of our millions of members who are subjected to those threats and intimidation, actual violence, and the whole point was to stop them, to interfere with their democratic right to vote. We have shown you that in certain areas where we had made inroads, in Nyamira, Kisii, Mombasa, Bungoma, and elsewhere, The whole point of that violence and intimidation directed against our membership was again to make them keep away from exercising their democratic right to vote. And we have also shown you that our members suffered extensive loss of property, to life also, due to these acts of violence. And it is quite clear, therefore, that in terms of safeguarding and articulating our members' rights, we are natural parties to this petition. In paragraph 11, we tell you that our candidate was also subjected to threats, character assassination. It is all highlighted in this petition, and it is important that we come in and contribute to this. What prejudice do we suffer is the second test is given in paragraph 12, where we say that none of the parties already enjoined in this petition as interested parties represent the special and unique interests of the members of the proposed interested party. Hence, we would not be in a position to highlight and submit on how the proposed interested party was directly affected by the acts of the respondent. So if we are omitted from these proceedings, our voice will not be heard, our position will not be articulated, we will suffer grave prejudice, hence the need to bring us in. And in terms of the third test of submissions, we have annexed to our application, right at the back, an outline of the position that we would articulate in this petition, and you will be able to peruse that when you retire. Very importantly, in paragraph 6, we have drawn your attention to an application that we filed in this court under certificate of urgency for contempt against these respondents. Our position was that they had wantonly flouted, disregarded the court order of 1st of September for the fresh elections to be held. We filed that application on the 19th of October. We have annexed it to this application, and the interesting thing is that up to now, these respondents have not even bothered to respond to that application for contempt. So in terms of demonstration of respect or disrespect for the rule of law, you can see the kind of persons we are dealing with. All in all, therefore, my lords, we have established sufficient basis why we should come in. We beg that we be admitted as an interested party and for us to participate alongside everybody else. In conclusion, we have not been served with any objection. We haven't seen any objection from any party, obviously because they think our presence here is highly merited. And unless there's any question, my lords, my ladies, I would leave it at that. Thank you.
Very well. Thank you, Mr. Reguero. Who is the respondent in this matter?
My Lord, I think the petitioner should go first, if I'm not wrong.
Sorry?
The petitioner in this petition, I believe, should go first.
Mr.
Kilokumi.
Mr. Kilokumi.
My Lord, the Chief Justice, Justices of the Supreme Court, the application before you is a discretionary matter which I would wish to leave to the court. Thank you.
Very well.
My Lords, we have responded to, we did respond to the petition by way of a notice of preliminary objection. And our position in this matter, my Lord, is that in the event that the preliminary objection is upheld, there will not even be need for the court to deal with the application for joinder. And so, my Lord, we are going to submit briefly on our preliminary objection, which we filed on the 11th of November 2017, together
Go on, Mr. Whelan.
Thank you, my Lord. We have filed the notice of preliminary objection. It's dated 11th of November 2017, and very extensive submissions on the same, of even date, and a list and a bundle of authorities, my Lord. My Lord, our position is this, in this matter is that the petition that is before you is not a presidential election petition. The petition, my Lord, raises a number of issues, which, my Lord, we concede that the court has power to investigate and to determine. But that power must be exercised within the jurisdictional limits of the court as established by the Constitution. In the event, my Lord, that you find that you do not have jurisdiction, or that the issues that have been raised in the petition fall outside of your jurisdictional limits, then, my Lord, in the timeless words of Nyarangi J.A., in the honors of M.V. Lillian S. versus Caltex Oil Kenya Limited, my Lords, you must down your tools forthwith. My Lord, the jurisdiction of this court is provided for under Article 163 of the Constitution. And, my Lord, it is three-pronged. You either have exclusive original jurisdiction, my Lord, or you have appellate jurisdiction, or you have jurisdiction to offer advisory opinions. My Lord, this petition does not seek an advisory opinion, and this petition is not an appeal from any matter from the lower courts. That leaves us, my Lord, with Article 163(3)(a) of the Constitution, which provides that your jurisdiction under that article shall be exercised in accordance with Article 140 of the Constitution. My Lord, under Article 140 of the Constitution, a person may file a petition in this court to challenge the election of a president-elect within 7 days after the date of the declaration of the results of the presidential election. If you look, my Lord, at Article 163(3)(a), you can only exercise your jurisdiction under that Article 140 on issues arising from a petition that has been filed, my Lords, to challenge the election of the president-elect. My Lord, you have had occasion to deal with this matter before in the case, my Lord, of Isaac Aluoch Polo Aluochier versus IBC, application number 2 of 2013. And in that case, my Lord, you spelled out your jurisdiction under Article 140 as follows. From the foregoing provisions, that is to say Article 163(3)(a) and 140 of the Constitution, it is clear that the Supreme Court has the powers to exercise exclusive original jurisdiction when dealing with issues as to the validity of the presidential election. My Lord, if you look at this petition, and my Lord, I would refer you to paragraph F at page 41 of that petition, the petitioner sets out the issues that arise out of this petition. And my lord, the issues are whether the respondents committed election offenses and engaged in serious electoral malpractices, whether the public has suffered loss and damage as a result of the respondents' acts and conduct, and what are the appropriate orders to be made by the court. Of course, we are aware that there are supplemental issues that were filed, but which revolve around the same issue. There is nowhere in this petition, my lord, where a challenge has been mounted on the declaration of the president-elect that is the subject of the petition number 4 of 2017. My lords, in essence, what we are saying is that in order to exercise your jurisdiction under Article 163(3)(a as read together with Article 140 of the Constitution, a petitioner must fulfill the following 3 cumulative conditions. 1, the dispute must relate to the election of the office of the president. That dispute must arise from a presidential election petition which challenges the result of that election. This petition does not meet that threshold, my lords. My lord, the petition raises a number of serious allegations against the first to the 5th respondents. Even if, my lord, you were to determine that you have jurisdiction to deal with this matter, it is impracticable that you would deal with them within the timelines that you have to deal with a presidential election petition under the Constitution. These are serious issues, my lord, and they are issues that require further investigation and cannot be dealt with within a presidential election petition. My lords, even for the High Court that has unlimited original jurisdiction, where such issues have been brought before them, they have declined to entertain them until the constitutional bodies that have been established to deal with fact-finding on such allegations as have been raised in this petition have had the opportunity to fact-find and to determine or verify the issues that have been raised in the context in which they've been raised in this petition. And they do so within the provisions, my lord, of the Elections Offences Act, which requires that as a first port of call, the DPP must be given an opportunity to investigate independently to determine the veracity of the issues that have been raised concerning an election offense. In the same way, my lord, to the extent that this petition seeks to find the first to 5th respondents as unfit to hold public office, we have a Leadership and Integrity Act, which again requires that any issues raised under that act be first dealt with by the EACC. And so, my lord, this petition is preemptive. In the event that you determine that you have jurisdiction to deal with this matter, it would not, in my view, be prudent to deal with these issues at this stage. Otherwise, you'll be usurping the powers of independent constitutional bodies that have been established under the very Constitution to deal with those issues. And so, my lord, in finishing, I would like to urge your lordships to also consider the same question that was asked by the Honorable Justice Lenaola. If you look at an answer to a presidential election petition, in the event that you were to respond to this petition as a presidential election petition, the rules that have been established by the Supreme Court Presidential Election Petition rules do not contemplate a response, an appropriate response to an election, a presidential election petition that does not challenge the results of a presidential election. In the event, my lord, we pray that this is a petition that is ripe for dismissal. I have, in my submissions, extensively provided authorities from this court, my lord, that have determined the extent and scope of that jurisdiction. this, in my view, was a petition that was well within the contemplation of the petitioner as to which jurisdiction would have been proper to take this petition to. And in the event, my Lord, this is a frivolous application that I think should be dismissed and be dismissed with costs. Thank you, my Lord. My time, I have 4 minutes left, which I cede to my senior, Professor Sihani.
My lords, my ladies, we concede the application being based on the court's discretion. However, we make the following submissions. Jurisdiction of the court is based on a four-pronged typology. 1 is the Constitution, 2 is statute, 3 is common law, 4th is equity. And we understand that he's approaching this court through the equity jurisdiction. My lords, electoral matters are not matters of equity. Equity comes in second. Equity isn't the basis for jurisdiction in electoral matters. It is the Constitution and statute that we must enter that debate through. And that is Article 163 on issues of original jurisdiction, appellate, and of course that's original and appellate with respect to this court. And presidential elections, this court has exclusive original jurisdiction. We are aware that this has not been canvassed, the basis of that jurisdiction which we thought to have been 163 as read was Article 140. And these matters have been addressed by this court and the Court of Appeal, among others before. For instance, the question of making so many allegations regarding election offenses, the William Kabogo case was very clear that in such a case, you go first to the relevant authorities, as my colleague has said. Go back first to the DPP to make those factual findings, go back to Ethics and Anti-Corruption Commission, among others. And therefore, this court also, the court has also expressed itself very clearly on the Peter Odworo-Ngoge case regarding jurisdictional limits, and jurisdiction is everything, as has been said in the MV Lillian case. It is everything. It cannot be taken for granted. My lords, Regulation 8 of this court's regulation are very clear on the grounds upon which a petition may be filed. I need not read all of them, but I need to read because of the interpretation that we want to give. 1A is the validity of the conduct of the presidential election. B is the validity of qualification to be president-elect. C is commission of election offense as provided for in the Election Offences Act. D is the validity of the nomination of presidential candidate. Any other ground. We submit that C, commission of an election offense, must be read ejusdem generis. It must be read in the context of the cited examples of bringing a presidential election petition. It cannot, it's not a standalone ground. Election offenses, you cannot just pop out from nowhere and say, I want to allege offenses, and particularly not against the agencies of supervising or conducting elections, not against the president-elect, but against somebody else. It can't be a presidential election petition. It is not challenging the election of the president. So that is absolutely clear. And if we look at the papers filed, it is actually a praise poem on the conduct of IBC. IBC conducted everything okay. IBC went out of its way. That is the language being used, which basically means to them they are not challenging the process. That is like at paragraph 16. They are saying IBC proceeded to provide detailed response, and then they reproduce IBC's responses. Paragraph 18, about 25 pages reproduced, despite IBC bending backwards. That is seeking to say that this process was basically okay, they are not challenging it, and therefore it cannot be a presidential election petition by any definition. My lords, my ladies, if this is an equitable jurisdiction, he who seeks equity must do equity, must also make sure that all the pleadings are proper and all the relevant parties are treated in the right way, not writing praise poetry for some parties and trying to condemn others, etc., etc. Lastly, my lords, if this is an equitable jurisdiction, we are also aware that equity follows the law. As we have agreed before, equity in the electoral matters can only be cited in the event that you have already cited the fundamentals of Article 140, Article 163 on the Supreme Court jurisdiction. You can't just say, I want an equity jurisdiction on these matters and I should be heard. Everybody has an equitable interest in presidential elections. Thank you.
Thank you.
My lords, the arguments that were made by Mr. Awele related to his PO on the petition itself. So those issues are properly dealt with by Mr. Kilukumi, and I'm sure he will have ample answer to that. And as far as Dr. Sihanya is concerned, I wish to respond to only one point, because he zeroed in on our application, and he says that equity seems to be the basis for our application for joinder. An incomprehensible submission to me. I cannot understand where that comes from. If you look at our notice of motion, you can see the provisions that we invoke. Substantive provisions of the Constitution, of statute, a Supreme Court Act, the rules of the Supreme Court, and so on. We are squarely within substantive law, and we have given basis for that. It's not just principles of equity. And even the authorities I have cited to you have set out, and that is really the test. That is the bedrock of our application. Have we met those three tests? And obviously we have. Mr. Kyoko responds to the petitional challenge.
My Lord, the Chief Justice, judges of this court. My Lord, I want to seek your guidance. When I was called upon to respond to the application by Jubilee for joinder. And my response was, this is a discretionary matter that I would leave for the court to deal with. When the counsel for the respondents took to the floor, they argued their appeal. So I'm seeking your guidance whether I now respond to the question of jurisdiction of this court. Yeah, that is. Sorry.
Mr. Kilokumi.
Yes, my Lord.
Because you see what the arguments by Mr. Wele and Professor Sianya are, is that forget about even the joinder of Jubilee in this matter. This is an non-starter. According to them, this is an non-starter. This court has no jurisdiction to entertain the matter. And if we were to uphold his argument, so I mean, Jubilee will have to will not come in.
Yes.
Are you ready to respond to the argument that this court has no jurisdiction to entertain your matter?
Yes, my Lord. I am ready to do it straight away.
Please go ahead.
Yes.
Yes.
My Lord, we filed written submissions on that issue of jurisdiction. It is to be found on paragraphs 13 through to paragraph 29. And the submissions are dated 13th November 2017. My Lord, there are 3 decisions from this Honorable Court confirming that they have jurisdiction to deal with a petition like the one before you, petition number 3. Almost 5 years ago, in advisory opinion number 2 of 2012, this court posed a question. And the question was, what is the exact limit of Article 141 of the Constitution? And in that decision, if I may trouble your lordships to just look at 3 paragraphs which are critical to the question, this is how the court framed the question. In paragraph 101 of that decision, does the entire question concerning presidential elections belong to the Supreme Court's jurisdiction, or is the Supreme Court power limited by the express language of Article 140 of the Constitution? Having posed that question, the court at paragraph 102 answered it this way. Besides, a reading of Article 87.2 alongside Article 163.3 suggests, as we perceive it, that the Supreme Court was intended to adjudicate upon all such disputes as would arise from the presidential election. We find no reason to presume that the framers of the Constitution intended that the Supreme Court should exercise original jurisdiction only in respect of specific element, namely disputes arising after the election, while excluding those disputes which might arise during the conduct of election. The petition before you raises issues that arose during the conduct of the election. And the issues are basically intimidation and violence perpetrated, orchestrated by the respondents. And then finally, at paragraph 106 of that decision, this court said as follows: presidential disputes in their whole range should be impartially and expeditiously resolved by the Supreme Court as the ultimate judicial body. I want to emphasize the words "in their whole range." And so since the delivery of this advisory opinion, it is clear that a party who needs to challenge any aspect of the presidential petition can come here, and the jurisdiction of this court is not in any way limited by Article 140. If you look at Article 140, it is procedural in nature. It says file your petition within 7 days. Determine that petition within 14 days. If the election is annulled, conduct an election within 60 days. That section has nothing to do with jurisdiction. The article that speaks to jurisdiction is Article 163(3)(a). And it uses very flexible language. And I will trouble your lordships with that article, 163(3)(a). The section reads, the article reads, the Supreme Court shall have exclusive original jurisdiction to hear and determine disputes relating to the election to the office of the president. And I want to emphasize the words relating to the election. This section does not limit your jurisdiction to determine validity or otherwise of an election. It is so broad, it is anything relating to that election. And this particular court has given interpretation to this section and say the whole range of disputes will be handled by this court exclusively. My lords, after delivering that judgment, Isaac Alwocher approached this court. And this court again confirmed that it has the jurisdiction to deal with disputes other than the question of validity of election of the president. And I want to refer to that decision. It is attached to the submissions put by the respondents. The Arrow Chair decision, the petitioner came to the court 27 days before the declaration of the result. He was not challenging the validity of the election. He was challenging the qualification of the president to contest the elections in 2013. This court, in that decision, struck out the petition of Mr. Arrow Chair, not because it had no jurisdiction, but because he had approached the court prematurely before the declaration of the results. My Lord, I would just want to get the paragraph so that I can read them to you. My Lord, I'll come back to Aruchel so that I save on time and pick the exact paragraphs.
Yeah, 7 minutes.
Yes. Then, in Raira 2013, Moses Kuria filed petition number 3, which was consolidated with petition number 5. What issue did Mr. Kuria bring before this court? He brought the question of how do you treat rejected votes. That petition is in the archives of this court. And when you look at that petition, there is no contestation about the validity of the election of the president. And what did this court do? It consolidated that petition with petition number 5, had it, and gave a determination. So from the jurisprudence coming from this court, the petitioners were well advised to file the petition that is before this court. There is the argument that Rule 8 should be read estem generis. The question of estem generis does not arise at all. The Rule 8 of the rules of this court, the petition rules, they distinctly lay out the different types of petitions that can be brought in this court. And that was a subject of interpretation in the Alvocher case. I just need to get it. I now have the Alvocher decision. The court in paragraph 30 in Alvocher listed the different types of petition that can come before this court. The court said, by the Supreme Court Presidential Election Petition Rules 2013, it is specifically provided that a presidential election petition is to be filed only after the declaration of the outcome. At that stage, as provided in Rule 12, a variant of pleas may be made, including those now raised by the petitioner. Then the court reproduces Rule 12 of the 2013 rules, which is exactly the same as Rule 8. It lists all the grounds. What I want to emphasize, my lords, is this. At paragraph 30, this court says you have different pleas that you can make. And they tell Advochair, your plea is one of them. Is the plea we've made before this court one which we can bring? Yes. In the 2013 rules, it read the commission of an election offense. In Rule 8C, it reads precisely the same, the commission of an election offense. And so it is our humble submission that there is sufficient case law from this court to confirm that indeed you can bring an election petition before this court to challenge any other ground that has been listed in the rules apart from the validity of the election of the president. My lords, I urge you to follow the rules of interpretation of the Constitution as laid down by this court, that you will holistically look at the Constitution. You are now being told by the respondents focus all your attention on Article 140, shut your eyes to Article 163(3)(a). Both articles must be read together under construction given. None of these articles should be read so as to be obliterated from the Constitution. They must be given meaning, both of them. My lords, you have been told that you will be usurping the constitutional role of other organs. That cannot be so. The intimidation and violence that the petition number 3 speaks to took place in the fresh presidential election held on the 26th of October 2017. The jurisdiction of this court is not co-shared. When this court sits as an election court in a presidential election, the jurisdiction is exclusive. So who are these other constitutional organs that you will leave the question of election offenses to? We submit there is no other organ. Section 87 of the Election Act is absolutely clear that if in the course of trying an election petition, election offenses were committed, the court is obligated, the election court is under an obligation to make that determination, and having made that determination, to send that report to the Director of Public Prosecutions. In the case of Moses Watengula, again a decision of this court, the court was clear that it does not sit, when it is exercising its jurisdiction as an election court, as a criminal court. It sits as an election court. But if crimes are committed which are likely to undermine the free will of expression of the electorate, the court must report those crimes to the DPP so that investigations are carried out. And so there is no conflict, nor can it be argued that there is no time to hear this plea. There is plenty of time. Election petition number 4 speaks about intimidation and violence. So inevitably, this court, in determining the petitions pending before it, will have to grapple with the question of violence and intimidation. And if we are allowed space, it would be useful to the court in fashioning a good remedy. Do you nullify an election because somebody, and here it is the respondents, deliberately orchestrated that violence, that intimidation, and they come to this court either directly or through their proxies, and they tell you, nullify the election. When we come and give the evidence, table the evidence, here are the people who committed that crime. The court is in a position to know which is the appropriate remedy to grant. Is it to nullify, or is it to subject the respondents to the criminal justice system? My lords, there was a complaint. Sorry, my lord. Let me conclude, my lord, by saying this, if you permit me. There is a complaint from the respondents. How do we respond to this case? There are forms that are prescribed under the petition rules of this court. Under Section 72 of the Interpretation and General Provisions Act, there is permission to deviate from prescribed forms. All what they needed to do is to file a response dealing with the petition that we have presented. For those reasons, my Lord the Chief Justice, Justices of the Supreme Court, please allow us a standing before this court. You have jurisdiction. I do not have the slightest doubt in my mind. Thank you, my lords. Yes. Thank you. Thank you.
Ladies and gentlemen, it's 6 o'clock. We will adjourn for 2 hours, come back, and continue. We must give what? We must deal with the pre-trial conference before we go to hearing. And the pre-trial conference has to be dealt with on the 8th day, which is today. So we'll come back at 8 o'clock.
That's what I'm going to ask you.